All right, this is Ricky,
And this is Brendan.
and you're listening to A Gentleman's Disagreement.
What I wouldn't give for the hope I used to find in a case of lion's head. Folks of different minds, because even though it did not share the pains we share, that American ideal, friends made over arguments in an early morning buzz. Need an early morning buzz.
All right, Brendan, it is August the 8th. I'm about to send you on a solo mission for an interview, but before I do, the U.S. women had a disappointing end to their World Cup run here, and it's been kind of a little bit of a hot button issue. So I'm just curious if you've got any thoughts on soccer in general. I know we're about to embark on a new EPL season with a bit of a different look. Soccer world's being shaken up in all different kinds of ways right now.
Yeah, I feel like we can do a whole episode just on soccer, the state of soccer these days. You and I, our teams are facing off to kick off the Premier League weekend on Sunday, Liverpool and Chelsea. So we'll look forward to that. I don't know if I can name 5 players on Chelsea after this last year, which is very sad for me. But who knows? I'm sure by Sunday I'll be ready to go and I'll fire it up if we watch together. I got up and watched the women play on Sunday. Certainly disappointing loss. Probably the best game they played the entire tournament, but still just couldn't find the back of the net this tournament and lost in PKs in a heartbreaking way. If anybody watched or saw the highlights, the ball, I still not totally sure that it got over, but that's soccer, real any sports, I guess in general, games of inches. The U.S. team, they didn't look good all tournament. There's certainly no complaints that they deserve to be moving on at this point. It's the worst finish they've ever had in a World Cup since the Women's World Cup started in 91. They were the 2-time defending champs. But, there's a reason that no team, men's or women's, has ever gone back to back to back. And that's certainly showed this year with this team.
Yeah, that obviously there's a lot of God, I don't know why hoopla is the one word that comes to mind. That's probably a terrible word just in general. But surrounding this team because of both obviously their historical on-field success, but also a lot of the off the field political initiatives, for lack of a better word, in pushing for equal pay for the women's team. And largely to sort of touting their success in contrast to the men's team. It's funny. Funny is probably not the right word, but we're looking at a team that advanced through the group stage on the women's side, and for the men in the men's World Cup, anytime we advance through the group stage, that's the victory right there, and everything else is icing on the cake. Whereas in this side, there's nothing but disappointment because of how well they've done in the past. I told you I had a few hot takes on this. My number one is that this is actually good for the women's game just in general. I think better competition globally only serves to elevate women's sports and the game in particular, the greatest game, football in particular, just because you have it's obviously that one truly global sport, and the US have dominated, but in large part because of the resources that American women were receiving that many women elsewhere in the world, even though ours were substandard in many ways to what the men's team were receiving, still far and away a better type of development organization than women's sports in other places. Not to make any comments about that, but just to see the game kind of elevated and have it actually just be more challenging for us to get through. Obviously the results weren't there this time around, but I think in general it's a good thing.
Sure, and I'm not the first one to make this comparison, but the comparison between this women's soccer team and the 2004 men's basketball team who had a poor showing in Greece at the Olympics after years and decades of dominating the global game. All of a sudden, other countries were starting to catch up. And you see the same thing here. Not only is the United States out, but Germany's out, Brazil is out, Canada's out. And so, yeah, I think globally it's fair to say like the women's game is growing exponentially, which is good. And just like when we saw like basketball, who are the best players in the world right now? You have Jokic from Serbia and Doncic from Slovenia and Giannis from Greece and Joel from Africa. And that's, we could say for years that the United States had the best players in the world. Obviously, there were other great players in Canada and Australia, but now that's even more so. So, yeah, I agree with that. I do think there was a lot of ambivalence around this team, while in the past, with generally when people are rooting for United States teams, even at things like the Olympics, we've talked about it. You don't know who these people are 5 seconds before the race starts, but then as soon as you do, it's USA, USA, USA. And we've seen that across individual sports and team sports. But the women's team, they have been very active, or certainly some of the more visible members of their team have been very active outside, off the pitch. And for some people, that makes them heroes and role models and people to look up to. And for other people, it makes them villains in some ways. And so this was an interesting one, because you have a lot of people that were devastated by this loss and a lot of people that were cheering this loss. And quite honestly, as usual, I can see both sides of it.
Yeah. I feel like that, like the Venn diagram of like how when you're supposed to be, patriotic at all times, that all of a sudden the politics don't align with the way that you want them to align, and then the patriotism can go out the window. I always find that aspect of that to be a little bit interesting. But I think you said it kind of best, though. Soccer, especially because the World Cup's every 4 years, is one of those sports that's very difficult to three-peat, and it's also interesting to see at the highest level a little bit of like the politics of soccer, right? You had women who were there for their third World Cup, which meant that they had been on the team at least 12 years, if not longer, which, if you know anything about the national, or sort of like the international game, people in their 30s are typically sort of like the over the hill crowd when it comes to soccer, which is crazy to say, but it's sort of true. And that's basically one of these things that comes up a lot in soccer, is that like you have these aging stars, you owe them respect, but to what degree do you have to rely on them in these moments when other teams are putting forward all this like super young talent? Obviously, there's a lot of benefits that come with experience, but soccer is a very physical, very fast game. And so there's a lot of benefits that come with youth too. And unfortunately, our mix didn't work out. I think there were some coaching issues on top of a number of other things. The chemistry just didn't seem to be there the way it had been in previous tournaments. But I think all in all, we'll look back at this and see a women's game that continues to get better. And the product on the field is I think ultimately what's important. Is it entertaining? And it definitely is.
Yeah, and the beauty of the women's game is that we get the Olympics next year. The men's like national teams don't play in the Olympics. Well, like their U23 sides, but the women's play like their full teams. And so I think to your point, this will expedite the transition from the Megan Rapinoe and Alex Morgan, Julie Johnston-Ertz generation into like we saw Trinity Rodman and Sophia Smith and Alyssa Thompson. So yeah, they'll have another shot next year, which is great for them. I'm sure they'll be hungry now.
Yeah, for sure. Well, I took us in a bit of a roundabout way, but let's give the people a little bit of a sample of what they're going to hear for the rest of the episode.
Yeah, well, you're not going to talk for the rest of the episode, so you had to get it in these first few minutes and talk about whatever you want, which is great.
As I do.
We are going to hear again, and welcome back to the program, Professor Barry McDonald, who is a constitutional law and Supreme Court expert. He teaches out at Pepperdine at the Cruiser School of Law. I'll give him a longer introduction when he comes on, but He's written and appeared in many major publications writing on the Supreme Court and constitutional law. And so we had him on the program last year back in October. He gave his opinions like almost like a preview of the Supreme Court's term. So we're really excited to have him back to now do like a post review of the Supreme Court's term now that all the decisions are in. You and I did an episode a few weeks back looking at the political and social implications of some of the major decisions, but this is very much for the lawyers and law students and people that are really interested in like the law and the opinions. We'll dive into it with Professor McDonald. And so, yeah, it's really looking forward to it. We feel very grateful that he has now continued to give us his time, a recurring guest for anybody that listens to PMT too.
Yeah, definitely love the friends of the pod. Well, without further ado.
Whoa, we're not so fast, my friend. Before we get into it, we have to remind everyone the podcast is brought to you by the hardworking craftsmen over at Cannon Hill Woodworking, building handcrafted high-end custom tables and desks in Boston since 2018. That's Cannon with 2 N's. You can check them on Instagram or visit them online at www.cannonhillwood.com. Ricky, I got a good one for you, I think.
I'm ready.
All right. If I told you a convoluted joke about a golf club, a sheep, a stinging insect, a tree, in that scary clown movie, would you believe it?
Wow. I mean, you really put that one together.
I like it. I think it's good. Again, like as I said last time too, we should have a rating system for these. I'm giving myself like a 7 or an 8 on that one.
Yeah, no, creativity, high marks.
All right. Now let's bring on Professor McDonald. All right. We are now thrilled to welcome back to the program Professor Barry McDonald. Professor McDonald is a professor at the Caruso School of Law at Pepperdine University. He graduated from Loyola University of Chicago, then went on to Northwestern University Law School. After graduation, he clerked on the U.S. Court of Appeals for the 10th Circuit and then at the Supreme Court under Chief Justice Rehnquist. After that, he went on to work for the U.S. State Department and in private practice. Now, like I said, he teaches at the Caruso School of Law, where he teaches constitutional law, First Amendment law, comparative constitutional law, intellectual property law, and contracts law. He is a recognized expert on constitutional law in the U.S. Supreme Court and is frequently interviewed or writes in major media publications such as the New York Times, the Washington Post, CBS Evening News, CNN, Fox News, National Public Radio, Los Angeles Times, and of course, A Gentleman's Disagreement. Thank you so much for joining us again, Professor McDonald.
Oh, good to be here, Brendan.
So particularly excited to have you back, like we were just talking about, because if people have listened to the program for a while, Professor McDonald came on last October to preview some of the major cases that were on the Supreme Court's document. And we discussed what he thought the court might decide in some of these major cases. Now that we're on the other side of the court's decisions, really excited to hear his thoughts on what surprised him, what he thought, what happened, the things that he thought were going to happen that did happen or did not happen. So without further ado, let's get into it. We're going to talk about 5 major cases. We're going to talk about the affirmative action case, the free speech case, the voting rights case, the independent state legislature case, and the student loan case. So I want to start with the affirmative action case because back in October, you were very much like on the fence about this one, and more on the fence about it than I was actually. You were kind of like given some personal feelings that Justices Roberts and Kavanaugh and Barrett have. You saw the case potentially going either way. It wasn't as straightforward as a lot of court observers thought in your mind. So now, as I'm sure anybody listening to this knows, the affirmative action case struck down Harvard's and UNC's consideration of race, their race-conscious admissions programs, and essentially ended affirmative action in college admission. So, Professor, now that you've seen the case come out, you've read the opinions, I'm sure. What are your thoughts on that case?
Well, I mean, yes, it technically has ended affirmative action in college admissions, but in the last paragraph, Chief Justice Roberts was emphasizing that, well, you could always read about a person's racial experiences and take that into account, but you have to ignore the racial part of it. So I'm not sure how that's going to work. Harvard issued some statements that sort of mocked that, I thought, saying, okay, well, we'll read about racial experiences and we won't take into account race. I just don't know how that's going to work. And it's going to be interesting litigation after all this.
Well, the way I read that was he wanted to separate the box checking of check the box if you're Black or Hispanic, and that you're going to be kind of treated one way, which their admissions scores seem to indicate, versus that if you have a particular experience where you've been affected by race growing up, if that's a central part of your identity, that's something you could still write about in an essay, and the school could still consider that in your application.
Oh yeah, no, that's correct. But I mean, the $64 question is, how are you going to prevent schools from using racial experiences as a proxy for race in their admissions decision? It may be harder, I suppose, to justify that if the numbers are looking more towards sort of managing, diversity the way that Roberts accused Harvard and UNC of doing. But so I think a lot of questions remain, and we're just going to have to see how this all plays out in future litigation. It's not over by any means.
Oh, for sure. Not only in college admissions, but I think this certainly opens the door for attacking affirmative action programs across the board, whether it's in employment or internships or those sorts of things as well.
Correct. No question about that.
Yeah. So what did you think of Justice Thomas's opinion? Obviously, Justice Thomas has been at the forefront of trying to end affirmative action in higher education for decades now, and this is very much a vindication of his personal belief. So what did you think of his opinion?
Well, I thought it was pretty much what he had said on numerous occasions in these affirmative action or racial preference type cases, that he believes that racial preferences do a lot more harm than good. He's made the argument many times that they put minorities in competitive pools where they're overmatched and they end up hurting their scholastic achievements. He thinks that they, and I think, you almost hear him talking about his own personal experiences here. They sort of promote the stereotype that minorities can't make it on their own, without any assistance by white majorities, that sort of thing. And so I just think that, he's taken a very colorblind stance on the Constitution, and, that's a legitimate position to take. It's just that I don't think it, my own opinion is it doesn't, this goes for the whole majority opinion, not just Thomas's opinion. Color blindness as a matter of originalism, they love to tout originalism, is questionable, because, I mean, go back to the slaughterhouse cases. There's a paragraph towards the end of that decision where they're talking about the Equal Protection Clause. They talk about how it was designed to prevent ongoing discrimination against recently freed African Americans. And so the question is, if you're trying to grant racial preferences to combat past and ongoing discrimination, is that more in line with the historical purpose than the colorblind account? I tend to think that you could make arguments both ways. But I'm always a person that if there's a constitutional issue that's questionable or dubious, unless you can get, 7 or more justices to agree on the answer to that, you ought to leave it to the people. And here, what the court is doing is issuing another democracy busting opinion like they have in the Second Amendment cases and a lot of other cases, where they're not letting majorities decide these debatable constitutional issues. They're doing it, you know, by virtue of 5 or 6 votes on the Supreme Court. And I just think that's a wrong-headed approach.
That's really interesting, because clearly Roberts and Thomas and the majority here want to make the law of the land like a colorblind constitution. Like that, they rely heavily on Justice Harlan's dissent in Plessy v. Ferguson, and that our constitution is colorblind. And they read Brown to say that, like, doesn't matter, we shouldn't treat anybody differently based on their race. And again, these justices have been making these arguments for years and decades at this point. Obviously,
but they're cherry picking those statements out of the general context of Harlan's dissent, or out of the Brown decision, what the court was trying to accomplish, or what Harlan was trying to say.
Right. I think, and that's really Justice Jackson's point, I think, was that if you look at the goal of those decisions was to ensure that, like, Black Americans in particular had equal protection under the laws, while Justice Thomas and Roberts read it very differently, which I think is some of the disagreement here. I thought, to your other point, one of the main sources of disagreement here that I found most persuasive on the dissent was Justice Sotomayor writing that in order to overturn all of this precedent, you have to clear a very high bar. And essentially, while Roberts didn't explicitly overrule Grutter in his majority opinion, Thomas essentially says it is overruled in his concurrence. And I thought Justice Sotomayor's point about the lack of respect that she thought the majority was showing for precedent was strong.
Well, I mean, let's be real here, Brendan. Stare decisis is a dead letter now on the court. I mean, once they've elevated this factor of the quality of the reasoning of a prior decision to the most important factor they consider, I mean, that's in the eye of the beholder. Stare decisis, and both the conservatives and the liberals do it. They rely on it when it's convenient. They pay lip service to it when it's convenient. And, it's really tragic, because constitutional law really does have to be, stable, reliable, principled, consistent. I think in the last couple of decades, the court has made a mockery of stare decisis.
Interesting. I agree with you. And I think that was one of the running themes of this term of the court, of this debate. I think two of the main things, and I want to get into this at the end, but two of the main themes for me were debates over stare decisis and debates over standing, which I thought came up again and again in some of these arguments. But I want to quote from Sotomayor's dissent. She said, quote, "Lost arguments are not grounds to overrule a case. When proponents of these arguments, greater now in number on the court, return to fight old battles anew, it betrays an unrestrained disregard for precedent. It fosters the people's suspicions that bedrock principles are founded in the proclivities of individuals on this court, not in the law, and it degrades the integrity of our constitutional system of government." So that's essentially what she's saying, and I agree with you. Both sides will use stare decisis when it's convenient to them.
Yeah.
Yeah.
I mean, I love the rhetoric, but if both sides, sort of applied it genuinely and honestly, I'd have no problem with that. But, both have been guilty of that over the years. And, so it's hard to, it's really hard to take that kind of rhetoric seriously these days.
That's fair. I think Thomas has a very different approach, obviously, in that he's long been of the opinion that if the precedent is wrong, we should fix it. I don't care if the precedent was from 5 years ago, 50 years ago, 150 years ago. If it was wrong, we should fix it. And what do you think about that sort of approach?
Well, he says if it's demonstrably erroneous. Well, what's demonstrably erroneous? I mean, it's just a convenient cover for saying, oh, I don't like that decision in a lot of cases, I think. So, I mean, but, let me say this about Sotomayor's dissent. I agree with her that, if you look at how the court applied strict scrutiny in Grutter, whatever you want to say, I hear different versions. But if you look at how they applied strict scrutiny in Grutter and then how they applied it here, they look radically different. It's almost like as if you took Grutter and flipped it upside down in terms of what the court thought were compelling interests and narrow tailoring in Grutter. And so I think that and I don't like this about the court, the way it decides cases these days, where it effectively is overruling precedent without saying it. And it's doing that so as to look more judicial and not as political, but it's just intellectually dishonest. The only significant difference, I think, between Grutter and this case is the 25-year marker, which, O'Connor had just sort of thrown that out there as an idea, as a marker, really as a principle that colleges needed to periodically review their need to take race into account in order to achieve the required diversity. But it wasn't a requirement by any means.
Certainly, and it provided a convenient grounds for the majority to seize on and saying that, like, we can't have these things going on indefinitely into the future. But I think she did it 25 years because it was 25 years. Grutter was 25 years after Bakke, and she was kind of like, hey, I hope an additional 25 years these won't be necessary. That's how I read that.
Could be, yeah.
I have one final question for you on this case. Do you think that the Bakke reasoning, which for people listening that probably know the law pretty well, law students, lawyers, the reasoning in there, it was a splinter case, 6 different opinions. Justice Powell's reasoning ultimately becomes kind of like the prevailing reasoning going forward, which is that the state has a compelling interest in maintaining diversity. Do you think that actually weakened and hurt the case for affirmative action going forward? In other words, do you think if Bakke had come out and been like, the 14th Amendment was designed to protect African Americans and to ensure that, like, all of these past discriminations, states had the ability to try to remedy these past discriminations, would have had a stronger constitutional basis than this kind of amorphous, we're in favor of the compelling diversity?
I don't know if it would have weakened the case, but it certainly would have. Powell marched through, I think, 3 interests asserted by California before he said, no, those don't work, and diversity works. And he didn't spend a lot of time and effort explaining why those other 3 interests were illegitimate. Like, for example, remedying past discrimination. He just thought, oh, that looks too much like a quote or whatever, And I just think that if there had been more to shore up, diversity could have been one reason, or maybe not a reason at all. But I think that there could have been other grounds that may have made it. If Powell had framed his opinion that, okay, well, we are a court and we're not here to impose our policies on the American people. And so, if there's a good case that when a Democratic majority, either at the federal, state, local, county level, or even at the level of public universities that are governed by board of trustees, if Democratic majorities want to accomplish this, better be really good reasons, pretty clear in the Constitution for us to say that they can't do that. And I think that if he had reasoned more along those lines, affirmative action would have stood a better chance. Now, I'm not saying I think that affirmative action is good as a public policy matter. I think that there are a lot of, and I don't take a position on that. I think that there are a lot of good arguments on both sides of that. I'm just talking here about the law and the Supreme Court's proper role in our constitutional system. And I just think that, once again, just like the Second Amendment, where it's far from clear that this demands that people be able to walk around with guns, Democratic majorities ought to be able to decide these difficult constitutional questions.
Yeah, I think and it seems like we're on similar pages here. It just seemed like Bakke was a very shaky foundational ground, which made it easier for the court to overturn precedent. It reminds me a little bit of like the Roe case, where if like Roe had more firmly like established this right to reproductive freedom and within the Constitution, it would have served it better. And again, it might not have been any different, the outcome of it, but it was just such like the foundation to me constitutionally seemed weak enough that it wouldn't be too difficult for a majority to overrule such an
Yeah, I think it's a combo there of both O'Connor and Powell, because O'Connor obviously had the opportunity in Grutter to sort of revisit Powell's reasoning, and she had a majority, I think, any way she wanted to go on that.
Right.
So, I think you could put some of that on Justice O'Connor.
Yeah, that's fair. And I mean, I think if you are a conservative, you would argue that these precedents, all of them rested on very weak grounds, which makes it makes it easier to overturn this precedent and respect other precedent. That would be the argument.
And let me be clear, I'm not a conservative, I'm not a liberal. I pride myself on trying to maintain a neutral, objective, nonpartisan analysis in these things.
That's why we like to have you here. All right, let's get into the second case, probably the most surprising case out of this term, which was the voting rights case out of Alabama, Allen v. Milligan. Essentially, Alabama was looking to overturn some of the court's precedent regarding Section 2 of the Voting Rights Act. Again, most of the listeners probably know this, but the Supreme Court has slowly but surely gutted the Voting Rights Act over the years, most notably in 2013 in Shelby. And Section 2 was really the only enforcement mechanism that the Supreme Court had previously allowed to remain. And Alabama was essentially trying to take that power out of that enforcement power out. The court ruled against it. And despite a long history of cutting down the Voting Rights Act, Roberts, again writing for the majority, upheld the Section 2 of the Voting Rights Act, relying heavily on precedent. So were you surprised by this, as surprised as most people were?
I guess I was, because, Roberts, has been on record, and especially in the parents involved case, is strongly saying we ought to get any sort of racial considerations out of the law. But of course, that there you're talking constitutional issues as opposed to statutory issues. But that's never stopped the court in the past when it wants to go a certain direction. But yeah, so I guess I was a little bit surprised that Kavanaugh and Roberts allied with the liberals to apply the voting rights, Section 2 of the Voting Rights Act, in the way that they did. But I was glad that they did it. Maybe they saw the three-punch wham, wham, wham of the against what they consider to be probably. Now, I'm not saying they personally take this stance, but the woke generation of Biden and all this stuff. They knew they were delivering the three-punch knockout of the First Amendment case, the student loan forgiveness case, and the affirmative action. So maybe they were thinking ahead and thinking, okay, we can't make this court look too political, so we need to be a little bit reasonable here.
Yeah, I mean, that certainly wouldn't surprise me if that's what Roberts was thinking, and Kavanaugh seems to be following in that mold a little bit in terms of concern about the integrity of the court. I'm sure we'll talk a little bit more about that later. To something that we had said earlier, Thomas's dissent in here says, quote, "In any event, stare decisis should be no barrier to reconsidering a line of cases that was based on a flawed method of statutory construction from its inception." So again, Roberts in his majority is relying on stare decisis here, and Thomas is pretty much saying that stare decisis is wrong and we should overturn this too.
Yeah, and I think that Roberts was really looking at sort of what he called the congressional compromise that Congress had made to allow these sort of Section 2 cases to go ahead based on discriminatory impact against minorities, where Congress, but also emphasized this doesn't mean proportional representation based on minority and majority populations in the state. And so I think he was just sort of saying that Gingles and the other precedents had honored that congressional compromise. And so he was, relying mainly on that.
Right. This does seem to me, I know you've been a bit derisive about like the court relying on stare decisis, and Roberts all but overturned stare decisis in the Harvard UNC cases. But if there's any justice on the court that I think still respects stare decisis, I do think it's Roberts, and that's what he's relying on a little bit here.
That could be, yeah. I mean, obviously he, he's trying to preserve the court's institutional reputation, and so, he, when I think he thinks that a result ought to go a certain way, he's not shy about upholding stare decisis. But I could point you to look at Citizens United. I mean, there was no reason to revisit the prior First Amendment decision, but courts, along with Roberts wrote a special opinion justifying it, why it was necessary to revisit this opinion. And so, I just think you need to take the whole record into account when you make these sort of observations.
That's fair. That's fair. So in a similar vein, one other case, which I was particularly interested in, was the independent state legislature case out of North Carolina. This is Moore v. Harper, where the North Carolina state legislature was essentially arguing that because of the elections clause of the federal constitution, they should be able to prescribe the time, place, and manner of federal elections, essentially free from oversight from anybody, including at least at the state level, including the state judiciary. We had talked about this back in October, and you were concerned a little bit about the potential for the court to uphold this theory, this what was originally a novel fringe theory of the independent state legislature. But we come out with Roberts writing again in a 6-3 majority that rejected this theory. So thoughts on that case?
Yeah, well, I was pleased that both Roberts, Kavanaugh, and Barrett all together sort of refused to go to the we had 3 justices, as you know, willing to. It was a fallacious theory from the beginning. I thought it was outlandish, really. But, the fact that 3 justices went there trying to support this was, in my opinion, ridiculous. So it was good to see that those 3 are at least willing to be reasonable in the face of legal arguments that are highly questionable.
Yeah, I want to get into the legal arguments in a minute, but again, for Roberts here, he's relying on stare precedent, the Arizona state district and commission from a few years prior. And I thought it was interesting because he was in the dissent on that case, but he relies on the majority in that case to continue to uphold this precedent as he sees it.
Well, that was the third in a line of precedents he drew on, and he said that there was unanimous agreement on the principle that you can't take state courts out of the state lawmaking processes. So I think that was a different case because it had to do with an independent commission to redraw, taking those decisions totally outside the hands of the legislature. And so I think he did have a colorable claim that this decision was consistent with sort of the majority views in that case, both the dissenting and the majority opinions.
Fair. The case, I was disappointed in reading it a little bit because the argument was really about the standing, whether or not there was standing, as opposed to the actual election clause argument. I wish there was more, but I wish Gorsuch had written this dissent. Thomas wrote it, but Thomas spends most of his time saying that the court that should never have heard the case because it was moot. But they don't get into the election arguments, the election clause argument as much. Thomas does talk about it briefly, where he says that he finds them persuasive, and Gorsuch and Alito sign on to this. Why did you find it so, as what you put it, fallacious? Why did you think that argument was so ridiculous?
Well, because you're talking about a provision in the Constitution that was meant to sort of assign responsibilities over federal elections, and to say that, okay, well, state legislatures are going to have primary responsibility for setting the rules in terms of the time, place, and manner of federal elections, subject to congressional oversight. And so it was just assigning responsibility between the federal and the state government. It wasn't trying to probe into state lawmaking processes or affect that division of responsibility at all. So I think that the argument itself it's similar to this sort of action, inaction, specious distinction that they trotted out in the Obamacare case. When I heard, I just thought that's absolutely absurd. I thought the same thing here, but that distinction actually won in the Obamacare cases. But it was good that sort of more reasonable heads prevailed in this case.
All right, fair enough. The fourth case I want to talk about, and I'm exceptionally glad that you're here because this is part of your area of expertise, is the free speech case out of Colorado, 303 Creative versus Ennis. And in this case, Elenis, in this case, a woman who we may not want to get into this, who theoretically was setting up a business to design websites for weddings, was afraid that if a homosexual couple approached her and asked her to design a website for them, for their marriage, that she would be forced to do it under Colorado's Anti-Discrimination Act. And she was arguing that it would essentially compel her to speak in a way that violated her First Amendment rights. The court agreed with her and said that she should not be forced to create a website for couples whose marriage she disagreed with. In some ways, people are saying that this is like a victory for First Amendment rights. In other ways, people are saying this is a real step back for LGBTQ rights in this country. Did you come down on one side or the other, or do you see it as both?
Well, I see this as a fairly narrow ruling because of the fact that in Gorsuch, in his majority opinion, relied heavily on the stipulations made by the state of Colorado, which a lot of people in hindsight are criticizing Colorado for having done, stipulating that, you know, if she designed a wedding website on behalf of a gay couple, that, you know, the Colorado said, okay, yes, then we're basically making you speak a message that can be attributed, at least in part, to you, of celebrating gay weddings, you know, and, you know, once you say that, you've sort of taken away a lot of the legal objections, because now you can invoke, you know, the Hurley decision about the same-sex contingent in a parade.
Right here in Boston.
Yeah, and the Dale versus Boy Scouts, and the you know, and then the Barnett decision to say the state can't force you to speak a message you don't believe in, you know, and then it becomes sort of an easy case.
Right. And Gorsuch, reading his opinion, it seemed like he treated it as a very easy case. I mean, his argument is very easy to follow. And at one point, I think he says, like, what are we even debating here? Like, obviously, this would violate the First Amendment.
Oh, it was based on these stipulations.
Right.
By the state of Colorado. You know, I you know, it's a head scratching why they made all these stipulations. So I think that, you know, but this case could open up a real can of worms. You know, all the other cases along these lines, like Masterpiece Cake Shop, have been decided on freedom of religion grounds. This creates sort of a general free speech right to, if you hold a sincere belief that you don't want to serve certain people in the marketplace, now, you know, this case sort of opens up that can of worms. You know, if I'm if I am a portrait artist and you know, I'm a white supremacist, and a black couple comes into my shop, and I don't believe that, you know, black people are entitled to have their portraits drawn, now I have a free speech right not to do it. Now, I think that's extremely troubling. And I think what's going to distinguish what these cases are going to turn on is sort of the stipulations in the Colorado made. And so I think it's going to open up grounds for a lot of arguments that, okay, well, if you didn't have those stipulations, here's a lot of other considerations. So it's just going to create a big mess of litigation.
Right. In this case, the majority of dissent seem to be talking past each other largely, as Gorsuch is relying heavily on a free speech case. And if you read his decision, it seems like there's no other possible outcome, that this would be a violation of the woman's First Amendment free speech rights. And like it would be hard to read the argument and disagree with that. But Justice Sotomayor, in her dissent, kind of takes a different tact. It argues essentially what you're saying, is that, I think she says, quote, today the court for the first time in its history grants a business open to the public a constitutional right to refuse to serve members of a protected class. And her dissent is all about like public accommodations law. And I'm curious, one, do you think there's an appetite on this court, or potentially like more largely within the federal judiciary to walk back some of the public accommodations doctrines that have existed since like the civil rights. Heart of Atlanta, I think, is the case that like really first establishes it. Do you think there's any sort of appetite to try to walk that back, or was this purely the majority being like, this is a free speech case, this is clearly violating her First Amendment?
You mean outside the arena of expressive goods and services?
Yeah. So like
that don't implicate First Amendment?
No, I think getting to like your earlier point of like if there are more challenges, First Amendment challenges to discrimination, do you think there's an appetite in this court to hear those types of arguments?
Oh, well, I definitely do, especially when you're talking about freedom of religion. But even now with this precedent, freedom of speech as well, freedom of belief. That's why I think it really opens a can of worms here. But I don't think there's an appetite to walk back public accommodations law outside the arena of somebody providing expressive goods or services to the marketplace that actually implicates the First Amendment.
Okay, that's fair. But I do think like this is, if you're looking at this court, we have like we have freedom of religion in the First Amendment, that now we have freedom of expression in the First Amendment, but now like this freedom of association, I think could be like another ground where people could start to push back on like public accommodations type laws.
Sure, like in the Boy Scouts versus Dale case, they have that precedent already out there. What struck me though about this decision is I thought it went, perhaps not surprisingly, it was more sort of on the right or conservative than it needed to be, because a lot of times in cases where the government is forcing you to speak a message you don't want to speak, the rule is, oh, you just don't automatically win, that strict scrutiny applies. And then you ask, does the government have a compelling interest? And even if it does, are there alternative ways to achieve it? And the state of Colorado was, I think, focusing on that because they were arguing, look, this person's services here are unique. She's a specialist, etc., trying to say that there aren't good alternatives to serve same-sex couples with what she provides. And Gorsuch just sort of mowed right through that and said, well, the more unique it is, the more reason we have to be to sort of protect our First Amendment rights. So I just think that now he's sort of providing a lot of ammo to say, well, it doesn't matter if there are alternatives for same-sex couples to acquire goods or services in the marketplace. We're going to sort of protect. We're just going to protect the speaker or the person that believes a certain belief, regardless of whether there are alternatives out there.
Right. That's where I do think there's, and maybe you're saying the same thing, I do think there's more of a door open to get into some of like that precedent. I could see Gorsuch in particular, and I would not shock me for Thomas and Alito too, and they're not going to be around forever, but saying something like, let the market decide. Like all of these laws that we have, like these public accommodation, like anti-discrimination laws, which Gorsuch writes, like Colorado has greatly expanded, as many states have, that now it's not just like public accommodations and common carriers. Now they pretty much apply to like almost any private business that opens itself up to the marketplace. And I could see justices like that arguing that these anti-discrimination laws do violate people's First Amendment rights in many ways.
It could be, of course, you've got to have a First Amendment claim, a religious objection or a speaking objection. But it could be, it's just hard to say how big of an arena of conflict that this is opening up, because it's just not clear how big a marketplace is for, goods or services that implicate, sufficient First Amendment concerns.
Yeah, no, I think that's totally fair. I was talking to a friend of mine who's he's gay man, he's married, and he was like, I love this case from a First Amendment perspective. He's like, I love protecting people's like First Amendment free speech rights. He's like, on the other hand, I don't like the potential for no gays that need to apply to like this service. And so I think I can see why people are like a little bit ambivalent about this type of case.
Well, I read about one gay advocate saying, "I love this case because now I can refuse to serve bigots."
Yeah, yeah,
Well, and that's true.
yeah.
But as long as he serves a expressive product or one that implicates his religious beliefs, but that's, I think, going to be the real question is, if you're a lawyer and you're a gay lawyer and you're asked to draft a will for somebody that is a bigot, an avowed bigot. Do you have a First Amendment right to decline to do that under this precedent? Is a will sufficiently expressive to invoke the First Amendment? That there's a lot of big questions that emerge from this case.
Yeah, no, I do think while Justice Gorsuch made it seem like a very straightforward decision, I think it's going to have, as you're kind of alluding to, some pretty large ramifications going forward, which I think will be really interesting. I think there's a lot of room for argument in this section of the law.
Yeah.
All right. Last case I want to talk about, and we didn't talk about this case back in October because it wasn't on the docket originally. This is the student loan case, Biden v. Nebraska. This got expedited review because of the millions of 43 million people that were kind of in limbo by the lower court's decisions. So obviously the court said that the Secretary of Education did not have the power under the 2003 HEROES Act to forgive $430 billion in student loans. Did this case surprise you at all?
No, not at all. I mean, this was basically a replay of the West Virginia versus EPA case about the Clean Air Act dispute. I knew that the court was leaning towards viewing this as a major questions case, but I know Roberts was still probably smarting from Kagan's barbed pen, her barbed dissent in the EPA case about the major questions. So it wasn't surprising to me at all that the first part of Roberts' opinion was he said, "Oh, this is just basic statutory interpretation." And even if it weren't, the major questions doctrine says that the Biden administration didn't have authority here. So he sort of hedged his bets. But Kagan's barbed pen flew again. I think she's becoming the Antonin Scalia of the left in terms of her witty, barbs and to the point where Roberts in the last paragraph of his opinion basically said, "Stop it, Elena, you're going to ruin the reputation of the Supreme Court." Yep. Well, come on, I mean. Scalia's dissents were just as barbed. I mean, look at his dissent in the same-sex marriage case. I mean, it was the Obergefell case. That was even more barbed, but
yeah, I think so. I had that line highlighted. Roberts at the end of his opinion says, quote, "It has become a disturbing feature of some recent opinions to criticize the decisions with which they agree as going beyond the proper role of the judiciary. We do not mistake this plainly heartfelt disagreement for disparagement. It is important that the public not be misled either. Any such misperception would be harmful to this institution and our country." And Kagan, as Professor you're alluding to, is pretty much saying that the court is going outside of the bounds of its business. It's inserting its policy judgments instead in place of Congress's and the executive branch here.
Yeah, and that's the same complaint that a lot of liberal majorities have, or I should say, that's the same complaint that a lot of conservative dissenters have made against liberal majorities. I mean, so you read this stuff and okay, trotting out the rhetoric here. Yeah. But it's true. I mean, that doesn't mean it's any less true. I do think that the conservatives have sort of made up this major questions doctrine. In good part, I'm not saying exclusively for the exclusive reason, but in good part because they disagree with a lot of the policies underlying a lot of these Democratic administrations. But the shoe fits on both sides. You go back in time, and the liberal majorities were doing the same thing. I mean, so it's just we need Supreme Court reform in a big way. To make this as not a nonpartisan a tribunal as possible, but we're sort of going to muddle through all this because that's impossible to get that kind of reform with Congress the way it is.
Well, what sort of reform would you be in favor of?
Well, I mean, I would be in favor of starting from scratch and just rethinking this from the ground up. I did have it, if you're really interested, I did have some suggestions in the New York Times in an op-ed piece I wrote there. I mean, the simplest thing would be simply for Congress to increase the size of the court in a non-packing way, in a way that, you know, every 2 years you add a seat. So you don't know who's going to benefit from that until you got to 15 or 17 justices. That's not a cure-all by any means, but I think it's the easiest fix, where it makes it harder for these sort of partisan voting blocks to form. I think you just get better decision-making out of multi-member judicial bodies. You know, look at the European Court of Human Rights. That starts with panels, but if it goes to the full European Court, you have 47 justices looking at a particular issue. I just think it makes for better judicial decision-making. I'm not saying it's a cure-all, it's not. You know, I do think we could impose term limits without a constitutional amendment. I mean, you know, you talk about good behavior. Well, that doesn't necessarily say it's a lifetime. And the way they've, you know, both sides, the liberals and conservatives, have stretched constitutional provisions in their interpretations, this would not be, you know, beyond that at all in terms of stretching the meaning of the Constitution. So term limits, increasing the size of the court in a non-packing way, I just think, you know, would be the easiest fixes. But if we were going to restart our thinking about all this, I think we'd have to focus not just on the court, but on our whole constitutional system, because the real problem is that the founders never envisioned the rapid rise of organized, national, polarized political parties, the two-party system. They never envisioned that, and they certainly didn't build it into the Constitution. They were looking at George Washington, you know, as the leader of the country, who despised partisan politics. But as soon as he stepped down, boy, those political parties just began to fill the void, and our system just wasn't built for that. We need to look at the candidates that we put forward in presidential elections. We need to give the public better choices, you know, more moderate choices, not ones that are supported by the extreme money on both sides of the political spectrum. It's just you know, I think the New York Times did a good expose on this thing in terms of how we sort of rebuild our democratic institutions. I contributed to that. There were other contributors. You know, it might be worth for people to look at.
Yeah, no, that's great. Some fascinating and somewhat radical suggestions. One other thing that you brought up earlier that I wanted to come back to is that you said that the Supreme Court in recent decades has not had a ton of respect for stare decisis. And I think it's easy to get caught up in like this court in particular not having that respect. But is this you're saying that you've seen this trend for a long time now?
I don't think that either side has let stare decisis stand in the way when they feel like, you know, they really want to sort of overturn a major decision. But I do think that the conservatives have made it a lot easier to disregard stare decisis. If you look at the factors that, like, for example, you go back to Casey versus Planned Parenthood, which was all about stare decisis, Roe versus Wade. You didn't even see really O'Connor in the factors of stare decisis talking about the quality of the prior reasoning. I mean, for obvious reasons, that's in the eye of the beholder.
Right.
But now it's become the most important factor for the conservatives. And, you know, once you say that, you know, stare decisis is just, you know, it's just lip service after that.
So you're saying that it's really, even though this maybe have been trending for a little while, it's really kind of fallen off a cliff in the last couple of terms.
Yes.
Okay. And so I guess like final thoughts, now we've had 2 terms of this court. Did this past term change your perceptions at all, reinforce certain things? Like now that we're starting to see this court more fully flesh itself out, it was hard with Barrett's first term, and now this was Jackson's first term, but thoughts on this court now 2 terms in?
I think it's a very bold conservative court. I mean, and they're not shy about overturning precedents that they don't like. And I don't know how many more are out there that they may be gunning for, because they've certainly shot down a lot of them. But I do think that, you have the sort of the moderate right forming of Roberts and Kavanaugh, maybe sometimes Barrett, that are going to try to rein that in a little bit, but even they are willing to sign on to overruling substantial decisions in traditional conservative contested areas. What surprised me is that conservative majority has been so brash. As soon as they got power, they started whacking these things down. And even amidst all this heavy criticism that they have become a political institution. And if so, they should answer to the voters and not have lifetime appointments to issue their decrees on the American people. And they just don't seem to care about that anymore.
Yeah.
It's become sort of a power game. And I think you see that bleeding over into this whole ethics controversy. Yeah. I mean, the revelations coming out recently are stunning, in terms of the behavior of some of these Supreme Court justices. In an earlier day, some of them would have clearly merited impeachment. It's just we've reached a new attitude where it's just sort of brass knuckles partisanship, and I think it's even infected the Supreme Court, and I do think it's damaging, for the country. But I don't want to overstate the Supreme Court's role. Obviously, we have problems in Congress and in the executive and at state levels. The Supreme Court is just one big cog in the wheel that we need to get our arms around this whole, partisan divide, this cultural war.
Yeah, that seems totally fair. It's been, even as someone that has agreed with many of the decisions over the past couple of years, it's been disappointing to see the regression of the court's image in the public eye over the past couple of years, for not only the decisions, but paired with all of the ethical things that have come out and just everything that's seen, even just like the process of getting some of these justices to the Supreme Court and how political that's been. So that has been disappointing.
Yeah. I agree.
Yeah. All right. Well, we can maybe hope for better in this upcoming term. Who knows what we'll see.
Well, I don't know what I'd have to think about it to see what else is out there for them to go into. But I think they've accomplished a lot of that work. Maybe things will get quieter for a while.
Yes, I think quieter would be a good thing. I've repeatedly said on our podcast that, like, I just can imagine Justice Roberts, and I know he's not blameless here, but like in his office, like kind of with his head in his hands, being like, come on, guy, like, what are we doing here?
Well, I would agree with that, except for his, joining the court in the Second Amendment cases, in this affirmative action thing. He's definitely on the side. He's a strongly conservative person. He's just sort of torn between the court's institutional interests and his own sort of conservative proclivities.
Yeah, I mean, but he seems the only one that's torn at all.
Well, I think Kavanaugh is indicating that he has a lot of angst about, these things. So, and that's a majority if you need it. So, to at least make it more of a centrist court. So I'm hoping
that's how you get the voting rights case, right? Like that's about it. Yeah,
exactly.
All right. Well, thank you so much again, Professor, for joining us, and we really appreciate your expertise and insight on this.
I don't know how expertise it is, but I appreciate always our conversations. It's always a lot of fun.
Yeah, no, it's been great. Thank you so much.
What I wouldn't give for the hope I used to find in a case of lion's head. Folks of different minds, because even though we did not share the pains we share, that American ideal, friends made over arguments in an early morning buzz. Need an early morning buzz.